Welcome to episode 8 of our on-site construction webinar series. I'm Teresa Mohammed, partner at Watson Farley & Williams, and I will outline what we're going to hear about today. First up, we're going to have adjudication updates, latest cases and trends by Ryland, partner at Watson Farley & Williams. This will be an overview of recent key judgments in respect of adjudication enforcement proceedings and commentary on the most common types of disputes in the construction industry at this time. And it will also look forward to the year ahead. Then we will have Keeping Up with Extension of Time Claims, the NEC Approach by Alexander Creswick, Senior Associate at Watson Farley & Williams. This will be practical insights into keeping on top of EOT claims during project delivery, focusing on the approach required under the NEC suite of construction contracts, including good practices and pitfalls to avoid. Then it will be Building Safety Act, ready for the April 2024 deadline by Barry Hembling, partner at Watson Farley & Williams. April's deadline for commencing work has important implications for projects. What needs to be done to comply, and we'll find out what happens if you don't. Then we have Uncanny Construction, Simon Murray, partner at William J. Marshall, our guest speaker. He will be talking about a scrutiny of compliance increases in various aspects of the construction industry, and as innovative technologies mature over time, previously unproblematic practices and products are emerging as problems. This talk will examine some recent examples where changing attitudes to compliance and increased technical understanding have presented challenges for the way we design, build, and maintain our built environment. There are just a couple of points of housekeeping. All microphones and video devices have been disabled and will remain disabled for the duration of the webinar. The webinar will last no longer than an hour and is being recorded. Questions are encouraged and will be answered at the end of today's webinar. Questions can be submitted using the Q&A function. If we don't have time to answer your question during the webinar, we will follow up with you personally in the next day or so. If you have dialed into the webinar, please email events@wfw.com to say that you've attended. Right, so let's hear from Ryland.
Good morning, everyone, and thank you very much, Teresa, for the introduction. So the topic of my talk today is recent trends in adjudication. And I thought I would start with some statistics. According to King's College London, in the period between May 22 and April 23, there were around 2,000 adjudication referrals. Now, of course, they're only the adjudication referrals that they are made aware of. There are obviously some that are private. So I suspect the real figure is much higher than that. If you compare that to, for example, claims in the Technology and Construction High Court, they are on average around 500 a year by way of claims issued, albeit not all of them make it through to trial, and quite a small proportion of them ever do. So that gives you an idea of how important adjudication is to the construction industry. According to King's College, smash and grab adjudication is still the most common, followed by extension of time claims. And what we're seeing is an increase in extension of time claims, in particular in relation to the consequences of the pandemic, now flowing through certainly into larger projects that have been ongoing. In terms of the cost of them, according to King's College, the sort of highest average is between 20 and 50,000 in terms of the cost to run, but they often exceed that depending on, of course, the value of those adjudications. And many of them are much less than that. Very few cases make it to enforcement in the courts, but the numbers are increasing. And on that note, I thought I would take you through 3 recent cases before the courts in relation to the enforcement of adjudication decisions. Now, this first case is interesting, I think, because it's anonymized. That's why it's described as AZ versus BY. And the reason it was anonymized by the judge in the judgment was because it was the subject of without prejudice evidence. And it appears to be the first decided case before the English courts in relation to this issue in the context of adjudication. Essentially what happened was AZ, the claimant here, was successful in their adjudication, but had relied upon documents that were described as without prejudice. And there was a question in the adjudication as to whether they should be entitled to do that. The adjudicator decided that they were entitled to rely upon those documents and in fact used those documents as part of the rationale for the decision. The responding party, BY, said that was wrong. and on that basis sought to resist enforcement. When it came before the judge, Mr. Justice Constable said that the documents were covered by the without prejudice privilege, and therefore they shouldn't have been either introduced or relied upon. And because of that, because they formed part of the rationale of the decision, they fed into what was seen as an unconscious or an apparent bias, which the court said therefore led to a breach of natural justice. And as a result, that decision was not binding. So I think the key point here is that you've got to be extra careful in terms of the evidence that is relied upon in adjudication proceedings. And it's not always obvious whether something is without prejudice. In fact, communications can be without prejudice, even though they don't state on them that they are without prejudice. The question really is whether they form part of a genuine negotiation wherein there is a concession being put forward by one or other of the parties with the aim to seeking settlement. So I think the key point is to make sure that any documents that are without prejudice are very clearly stated as being such. And if any party in an adjudication seeks to rely upon them, they should be flagged immediately to an adjudicator and the other side. And it should be pointed out that following this case, they simply shouldn't form part of any submissions in the adjudication. The next case that I'd like to discuss, once my slides catch up, it is a 2024 case, a very, very recent judgment, which I thought would be of interest. The first point to note, for those of you that are sufficiently awake at this time, you'll see that the claimant was Roundel Manufacturing, even though the case is called Bellway versus Sergo. And the reason for that was that the claim, the entitlement to the claim for Roundel was assigned to Bellway, and therefore they were entitled to bring the case themselves in the name of Roundel. So Roundel engaged Sergo as a subcontractor. They applied for payment in December 22 for around 150k. Sergo failed to issue valid payment or pay less notice, and they commenced an adjudication which included seeking remedies from the adjudicator in relation to, number one, the entitlement to a smash and grab, and then in the alternative, if that failed, the true value, or I think that the phrasing is substantive assessment of the application for payment in the event that the smash and grab failed. Now, I have to say, I've been taking this approach for years and haven't had much of a problem, but it's good to know that my approach has now been verified as the correct one. When it got before the courts, there was quite a good debate in the Liverpool TCC about whether this was multiple disputes. At first blush, you might think that it could be. And the reason for that is if you look at Sir Rupert Jackson's judgment in Grove and S&T, that there is reference in other cases as well to the distinction between the payment bargain in a construction contract and the value bargain. That is to say, the payment bargain arises when there's an application for payment and there's no response to it, and the value bargain in relation to the underlying intrinsic or true value of the works undertaken. So on the face of that, one might think, well, that is different disputes. And it's also interesting in the context of the idea that one must pay now and argue later, because that would suggest that they're different disputes. However, it very much depends, and this case is no exception, on how the dispute is phrased. And if a dispute is skillfully phrased as a single dispute in relation to the amounts due in respect of a single period, which is what happened here, the court had no hesitation in saying, well, actually, an alternative way to achieve the answer to that question by way of true value is not wrong. It's not multiple disputes. It's still the same dispute. And lawyers can be very creative and in terms of creating alternative arguments, and there's nothing wrong with that. So the court held in this case that it wasn't more than one dispute, and the decision was binding. And on that basis, I think what we'll effectively now see is an increase in the number of cases that are run on the basis of a smash and grab with the true value in the alternative. The third case that I'd like to outline this morning is Lancashire Schools and Lendlease, another case from this year. And this is, again, slightly unusual, actually. This case is in relation to a PFI contract, which contained a mandatory adjudication clause. In other words, the contract said you must adjudicate before you litigate. And essentially, the parties didn't adjudicate and went straight for litigation. The court concluded that the adjudication was a mandatory step, so it was essentially a breach of contract for failing to follow that process, but the claim should not be struck out or stayed. Essentially, this was a holistic approach by the courts, and really a demonstration of the sort of fairly wide-ranging discretion that a court has when faced with an application to strike out. And the court found that it had discretion to continue with the claim, in other words, not to strike it out, because there are a number of other parties who it could affect. And actually, it was quite derogatory towards adjudication, I think. In the judgment, it says that there probably wouldn't have been anything particularly useful concluded in the adjudication. I think what probably the court was thinking there was that ultimately adjudication is only interim binding until the courts would deal with it finally, and therefore it would be inevitable that it would come back to the courts. So it's a reminder that mandatory adjudication provisions may be overruled or can be circumvented. So really, I think in terms of recent trends, what we can see here is that the likelihood is that there'll be more adjudications. The numbers will increase. The numbers stated don't include private adjudications. They don't include cases that are transferred either. And so I think what we're seeing is that the TCC is maintaining its tradition of upholding decisions on the one hand, but the nature of technical challenge to those adjudications is certainly becoming more complex. And I think what we will see is a continuation of smash and grab claims, but possibly more true value adjudication in the alternative. But there's a word of warning on true value adjudications. Whilst the smash and grab is very good at getting a quick decision, not analysing the merits, maintaining cash flow, protecting the procurement chain, and ensuring timely completion if it's undertaken during the work. These are all good things for the blood lifeline of construction, as Sir Michael Latham put it. But it doesn't necessarily resolve the underlying dispute. And so parties need to think carefully about whether they're ready for a true value adjudication. So a word of warning, I would say that if you're going to run that as an alternative, you've got to make sure that your notices are in place in relation to any claims, that you've got the substantiation ready, and that any delay analysis is also up to date. And then there's a question, well, if you're going to go that far, should you be involving, potentially involving experts for delay and quantum? And I think in many cases that would be a good idea if there's a significant difference between the parties. But ultimately, my message here is that disputes like this can be avoided by the use of project counsel advice, which we are increasingly offering clients, to avoid disputes from the very start of a project and on an ongoing basis throughout the life cycle of the project, to ensure that all of these processes can ultimately be avoided. Thank you very much for listening. I'm going to now pass over to Alexander Creswick, who's going to talk about keeping up with extensions of time under the NEC contract.
Thank you, Ryland. Thanks very much. We can move on to the next slide, please. So morning, everyone. So this morning, the subject of delay claims and claims for extension of time is a substantial topic. I don't intend to attempt to summarize everything that you could in the 10 or so minutes that I'm going to be speaking today. We regularly provide training to clients on this subject, which can take, a full day's training and still leave lots of sub issues that could warrant further training in their own right. So it is a massive topic. What I'm aiming to cover this morning is the difficulties of trying to keep on top of causes of delay and contractor claims for extensions of time during the conduct of the project. There are definitely advantages to trying to keep up with those claims as the project progresses, rather than leaving them all to the end and trying to do a sort of a global delay claim or dispute retrospectively. And this proactive approach is something that will be familiar to those of you who are used to working with NEC contracts, but it might be slightly more alien to those used to working with other forms of construction contracts, such as JCT, FIDIC, or IChemE, for example. The overarching principle that the NEC contracts adopt is that the causes of delay and the compensation events that give rise to them are notified as soon as they arise, and their effect is impacted on the project program contemporaneously and on a mostly forecast basis. The advantage of this is that the parties have transparency as to how the works are progressing and what issues are delaying the works as they arise. That is supposed to allow the parties to work together to try and mitigate their effects. And it should also mean that there's no sort of surprise to the client or the employer at the end of the project or towards the end of the project that the works aren't going to be completed by the planned completion date. The problems that can arise, however, which I'll cover shortly, is that it can often be very difficult for project planners, programmers, or delay analysts to assess and manage accurately the extension of time or delay that the contractor considers it's entitled to, or will want to be recovering, to ensure that they're not left out of pocket from a time and money perspective by the end of the works. And so the prospective approach that is required in order to have your contemporaneous updating and managing of delay claims can lead to under recovery or over recovery from the contractor. Go to the next slide, please. So although the approach that the NEC adopts can be adopted under any sort of construction contract in theory, as I say, it's most commonly associated with the NEC. I'm going to focus this morning on the clause references, or the clause references I use are taken from the NEC 4 ECC form, but the principles are similar or virtually identical under NEC 3 and apply across most of the NEC suite of contracts. So the concept that's used in the NEC form is that of the accepted program. The accepted program starts its life either as the contract program stated in the contract data, or as a program which is submitted very early on by a prescribed time by the contractor in a prescribed time for acceptance by the project manager, the client's project manager. The accepted program is then revised at regular intervals, usually monthly. That's most typically what's prescribed by the contract data. And the project manager reviews it and decides whether they can accept it on behalf of the client. It can also be updated at the express request of the project manager, on the own volition of the contractor, or as part of implementing a compensation event. The quote that is on the screen at the moment is taken from the NEC guide on NEC 4 ECC contract. and give some insight into what the NEC drafters have in mind by this regime. So the NEC guide states the contractor and the project manager should both have a program available to use in assessing the cost and time impact of a compensation event. The program will doubtless have some differences between what is shown as having been completed and what has been completed, but these should not be significant over the lifetime of the accepted program. So, I mean, that is, in theory, a very good aim to have. And there can be advantages, as I'll come on to, by this approach and this aim. The problem is that because, as many people would argue, I think, the NEC is an inherently employer or client friendly contract, if the PM refuses to accept updates to the accepted program, and there starts to become a divergence between the parties in terms of what the accepted program should look like, and therefore you don't have regularly updated accepted programs through the works, then it can put the contractor in a very, very difficult position when it tries to claim for its extensions of time. And so that can often cause really serious issues for recovery for the contractor, and which, because delay is often a big chunk of where the additional money comes from in construction contracts, can cause cash flow problems for contractors. Next slide, please. So, as many of you will no doubt be aware, the mechanism for claiming an extension of time under the NEC contract is through compensation events. The clause, I'm not going to go through the whole compensation event regime, but as set out in clause 63.5 of the NEC 4 ECC form, which is up on the screen, this is how a delay and therefore an EOT claim is quoted and assessed by the contractor or by the PM if they reject the quotation. It's worth noting that the bullet points you see on the screen were added or replaced some wording in 63.5 in a 2019 update, and therefore if you're looking at older hard copy versions of the NEC 4 contract, it might look different, and so you just need to be aware of that when you are using this clause. The effects of the amendment are not massive, but it does sort of clarify the way that this is supposed to be done. So in effect, this is a time impact analysis, or it's akin to a time impact analysis. The accepted program that was most up to date as at the time, as at the dividing date, which will be either the date of a PM's instruction, if the CE arising from an instruction, or the date of that the compensation event was notified if it's any other basis for a CE. That program will be updated using as-built data that's available to, and also any other delay that's already been caused by the compensation event in question. And that updated baseline accepted program will then have the CE impacted on it to forecast the critical delay caused to the planned date for completion. And the number of days that the planned date for completion has changed or been pushed back compared to what was stated in the accepted program will be the number of days EOT that the contractor is entitled to for that CE. Where issues usually arise and where delay analysts find difficulty with this approach is that, in principle, the contract requires them not to correct or fiddle around with any logic or obvious errors in the forecast element of the accepted program. Any such errors that need to be corrected should be corrected when the accepted program is being updated on a regular basis or following instruction to do so, or on the contractor's own volition. And so this can often be very difficult for delay analysts to do because they just don't like to do something that is obviously wrong when they are assessing the number of days delay. And so that can also usually be an area of dispute between PM and the contractor. Next slide, please. So that's the basic regime, and that's the principle how NEC works, and that's something that you could adopt equally in other forms of contract with bespoke amendments, etc. But what are the problems with it? Well, the first problem is it relies on the accuracy and logic of the accepted program. So if you don't have a regularly updated accepted program because the parties have been unable to agree one, or if there were some real serious problems in the original baseline program because it wasn't accurate, then that can mean that forecasting the impact of the CE and then making sure that you are able to recover all of the delay that the contractor thinks they're entitled to can be quite difficult. The second problem with it is, as I mentioned, it doesn't expressly allow in the contract, or doesn't envisage, that the contractor will correct any obvious errors in the forecasted element of the accepted program. They can do that through other regimes within the contract, as mentioned, and arguably they can do it as part of the implementation of the CE, but that might leave them out of pocket in terms of time impact if there are underlying problems with the accepted program. Because it is a forecast prospective analysis from the dividing date onwards, it can mean that it doesn't account or allow for where the critical path is changed, and this can be a problem later on, and this can be a problem for the employer in particular. And then finally, there's just some other bits. It doesn't allow for consequential delay in disruption to be claimed if you don't include that as a risk element. And also the contractor may be overcompensated or undercompensated. So, just an example, we've had an issue on a project where the CE has pushed activities into winter working, but it's really hard to work out how that winter working at the CE assessment level, it's really hard to work out how the winter working is going to impact those activities and therefore claim for it. And it's trying to deal with that. So just moving on to the final slide and I'm wrapping up, please. Sorry, that's next slide, please. Thanks. There's some key things to consider to try and avoid these problems. First of all, it's making sure the accepted program is regularly updated. And if you can't get an accepted program, considering whether you need to adjudicate to try and force through an updated accepted program, especially where you have a long project. Making sure that CE quotations are submitted in time so that you aren't getting a build-up of EOT claims and compensation event disputes. Making sure your delay analysis complies with the contract so that the project manager can't reject your claims on the basis you haven't claimed for it properly. And then also including adequate risk allowance and make use of assumptions in the quotation. So the way to do this is for a contractor is to include risk allowance for potential disruption or consequential impact later on that might be foreseeable. And if the PM refuses to accept it, then requiring or trying to require them to include assumptions in the quotation about what that assessment is based on. And finally, just to wrap up thought, many of you will be aware of the case of Northern Ireland Housing Executive and Healthy Buildings Ireland, which is a Northern Irish case that considered whether you can take a retrospective approach to assessing claims under the NEC contract. Now, this case actually primarily related to claims for addition to the prices, not to delay, but it's often cited as a principle for allowing you to depart from the prospective approach under the NEC. There's a pretty clear, almost 50-50 split in the industry whether that actually should be followed or not. And so you will find in adjudications that often that will not come to your rescue if you think that your prospective approach is causing issues, and so you can just wait and do a retrospective approach at the end of the project. So hopefully, I mean, that was a very quick whistle-stop tour. There's time for questions at the end in terms of the pitfalls, if you'd like to raise them. Thank you very much. And I now hand over to Barry.
Thanks very much, Alex. That was a really good presentation. And in this session, we'll look at more changes being introduced by the Building Safety Act, which govern the regulation of the building control profession. So these changes are important because they directly impact on how projects are signed off and approved. And they're also complicated transitional provisions that you need to be aware about, because they will determine whether the old or the new regime will apply for the approval of projects. So all these points I will speak about in further detail over the next 10 minutes. So just by way of a refresh, the Building Safety Act, it's the most fundamental reform of construction, development and residential property sectors since the Second World War. Key measures include the new building safety regulator, a more rigorous regime for the planning, design and construction and operation of buildings, and a strengthening of the building control system. And they significantly impact anyone working in the construction and the development sectors. The Act applies throughout the UK, but there are significant variations between devolved administrations. And in terms of the measures that have been introduced, we've had a series of measures in preparation for the Act coming into force, and then the Act has been rolled out over recent months, and we're now at the far right of this chart, so the last of the measures that are being introduced right now. There are important changes being adopted for the building control profession from April 2024. And the aim is to strengthen the regulation of all local authority building control bodies and improve inspectors. So in summary of the key changes, approved inspectors become registered building control approvers. Regarding regulation, the building safety regulator will take over from CIC Air's current role in maintaining and operating the approved inspector register. Registration with the building safety regulator will be mandatory from next month. And these new registration requirements, they apply to local authority building control and also from improved inspectors. There are new regulations that were also enforced from the 1st of October, which are aimed at ensuring standardization and improvements across the public and private sectors. In terms of the registration process, so there's a first-time registration process for all individuals. Registration is envisaged to last about 4 years, and then registered building inspectors will be required to satisfy a code of conduct and competence framework prior to applying for re-registration at the end of that 4-year period. And it's worth saying that it's not necessary for local authorities to register as building control approvers themselves, because they already have that enforcement obligations. And the Act introduces new criminal sanctions. So it's a criminal offence to act outside the scope of a registration, and it's a criminal offence to impersonate a registered building control approver. There's also the introduction of a new code of conduct. The conduct code applies whether the approver works in private or the public sector, and it's designed to ensure consistency in the building control profession. Anyone who follows the construction press may have seen headlines commenting on progress with the registration process. Registration is still open for another couple of weeks, and we're all monitoring how that's going. In terms of what these measures mean in practice, so building control bodies need to use a registered building inspector to perform specified functions. Inspectors need to be registered. The building safety regulator will monitor the arrangements and collect information to ensure compliance. But there are two very important points that mean, by way of practical implications, why any of this matters. And the first is it determines who may and may not approve a project. So under the previous regime, once an approved inspector had been appointed, they would sign together with the developer the notification to the local authority on what was called an initial notice. So the approved inspector could sign the initial notice so long as they had authorization to do so. Under the new regime, the registered building control approver is approved to sign the initial notice, depending on various factors, such as whether the initial notice was given and by whom it was given, when the work start and finish, and whether the approver has been registered. There are some very complicated transitional provisions that determine whether or not the existing regime applies or whether it's necessary to transition to the new regime. Time doesn't permit me to go through all the various permutations in detail, but the key takeaway is that if the approved inspector is registered under the new regime and the work's finished before April, then the old regime applies. If the initial notice was issued before the April deadline, the approved inspector is registered under the new regime under the April deadline, then again, you can still continue with the old regime. But there are more complicated provisions where the works are due to finish after October 2024 and where construction work hasn't started over by 6th of April 2024. So I think the key takeaway message has to be that if you're acting on a live project where there's an improved inspector, you need to check whether that improved inspector has authority to sign off the project, particularly if the project is due to complete after April 2024 and or where the approved inspector hasn't become registered. And the other important point to check is the initial notice. So the previous arrangements, the initial notice didn't have a lapse, but in order to ensure that the initial notice is kept up to date and is current with changes to the building regulations, there is this new introduction of a 3-year period for the initial notice, after which the initial notice lapses. So if the works don't start within that 3-year period, it's necessary to apply for a new initial notice. So it brings the initial notice arrangements in line with arrangements that we've previously seen in respect of planning permission. And again, there are very, very complicated transitional provisions for which it will be necessary to take expert advice. And those transitional provisions largely determined by whether or not the works have commenced on site. And the Act, amending the Building Act, imposes complicated transitional provisions based around whether the construction project is a complex building, whether it's a new building, or whether it's other type of building work. And in relation to other type of building work, you have this idea that at least 15% of the works need to be complete by the April deadline in order to preserve the initial notice. So again, I would suggest looking at those provisions in detail, taking expert advice and just making sure that not only is the approved inspector authorized to sign off the existing scheme, but that the initial notice remains valid and won't have lapsed. So in terms of summary and practical implications, the strengthened building control system will be widely welcome, no doubt, because it will introduce more rigorous oversight of the building control profession and the sign-off of buildings. But as we move to the new regime, there will be complicated transitional arrangements. So on live projects, you need to check whether the existing approved inspector has the authority to approve the project. And it's also necessary to confirm whether the initial notice has not expired and to diarise those expiry dates. As mentioned in summary, the new rules are complicated, particularly as we move from the old and the new arrangements prior to the 6th of April deadline. It's prudent to take expert advice in order to avoid being caught out. And I'm now delighted to hand over to our guest speaker for this session, Simon Murray of William J. Marshall, who will speak to us about uncanny construction.
Thanks, Barry, and thank you everybody for watching. My name's Simon Murray. I'm an architect and partner of William J. Marshall and Partners. We are a firm of architects and engineers specialising in expert and forensic work. I see a lot of problems in the construction industry. Sometimes that's things that are happening currently, or it's historic problems that have resurfaced following a dispute. Barry recently asked me to put together a presentation for this webinar on issues that I'm seeing in my work as an expert witness and so on, that would be of interest. So I've used the title uncanny architecture, oh sorry, uncanny construction rather, to cover what I'm going to talk about. The uncanny is a notion from psychology that describes an eerie sense of something that's both familiar and somehow also wrong or unsettling. And I get this sense sometimes in the matters that I'm investigating, when you get products or practices, words even, or diagrams that are taken for granted, but have been interpreted or reinterpreted as something quite different, which ends up in a dispute. And that's particularly the case, for example, in fire safety issues. This is important, of course, because the adequacy of a party's work isn't supposed to be assessed with hindsight. You can't look back and judge them by the standards of today with what they were doing before. But then again, something that's unsafe now presumably have been unsafe back then. So the question then arises, what were we doing wrong? Were we doing something wrong? And what else could we be doing wrong now? So over the course of months and years, there's obviously been changes in the understanding of different products like RAC, foam plastic insulation, ACM products, HPL, and now recently UPVC cladding on lower-rise buildings. I'm going to run through a couple of examples, so 3 items. One's a product, one is a construction type, and the other is a performance characteristic, and then try and draw some conclusions on how we avoid or learn from these sorts of experience of uncanny construction. So the first example here is CPVC pipework, which some of you may be aware of. It's a lovely orange coloured pipe and a material called chlorinated polyvinyl chloride, which have been used since the 80s in the US and then also in the UK and Europe from about the 2000s onwards, and is still popular for sprinklers and can be very robust. It's very lightweight relative to the alternatives that are steel and copper. It's quite cheap and easily worked, and seemingly resistant to chemicals as a very valuable asset. But it has a bit of an Achilles heel in that when it's used with certain chemicals, including those that are used in certain fire stopping products, it cracks and degrades and leads to leaks, which is obviously not good for sprinklers. So I've seen a number of installations where this has been used passing through fire-resistant walls. The wrong type of fire stopping has been used, and you've got a massive headache. The funny thing is that the knowledge of this weakness or this vulnerability has been known about for some time. There's even registers for some manufacturers of the suitable materials that can be used and things that can't. But the lack of awareness on some of these projects meant that serious problems resulted. And the solution for this really is just this sense of having greater awareness, and potentially the idea of controlling competence, as is proposed in the regulations following on from the Building Safety Act, is maybe a way of avoiding these sorts of things in the future. The next example is a construction type, so timber construction, innovative timber construction. Timber is a very attractive material. It has sustainability credentials, and it's very versatile as a material. It's very suitable for prefabrication and so on to create innovative structures. The problem is that when the fundamental principles that apply to timber construction are not accounted for, such as ventilation to allow drying, or the fact that these things are ultimately put together by humans on a building site, you end up with leaks, potentially condensation, potentially, and these can have a catastrophic effect. The solution to this is in part in the guidance that we get from organizations like Charter, the British standards. There are also very sophisticated modeling, even accommodating for defects and particular conditions. But ultimately, when you're innovating, you'll end up with blind spots because you're doing things necessarily for the first time, and they may not have been covered by previous examples. So the next point to look at is the fire performance and durability. Fire performance, obviously very important, and increasingly there is a desire and a need to have representative testing that reflects what's being installed, so that nuances such as something that's maybe curved or has notches in it can be reflected in the test information, which isn't currently the case in standardized testing, and isn't really practical in a lot of cases. But this is a thing that is considered to be more and more significant as the desire for certainty increases. Similarly, the performance of these products over time isn't generally tested. You'll have something straight out of the factory, test it, it works, but what happens in 5, 10, 15 years time? These are possibly, again, things that might be picked up by industry following on from the moves, the Building Safety Act and the Office for Product Safety and Standards. So reflecting back on these then, it's really a way of looking at our errors. Do we avoid errors? Do we learn from errors? There's a tension between innovation, which is an essential activity in construction, particularly nowadays as we're solving ever-shifting needs and trying to deal with climate change and many other things. We're often doing things for the first time, and how do we deal with the risk of that and of getting it wrong? So there's just a example there from history of the bent pyramid of Snefru in Egypt. Essentially, they started off trying to build the pyramid and realized halfway that it was too steep. So they had to crank it and make it shallower, which didn't meet the standard. So they had another go and got it right next time. This is the way that traditional architecture and construction practices used to work: trial and error until you got it right. We can't really afford to do that anymore. But nonetheless, mistakes will happen. And really the question is, how do we learn from those? So finally, just a reflection on all this. How do we learn from things? How do we capture that information, those errors, and how not to make those errors again? The examples we looked at included some overlooked basic principles that people forget about, underdeveloped guidance, and just straightforward errors. And how do we face up to those? How do we capture that in a way that stops that happening again? You can get things that are more like rules, but they can be blunt and admittedly effective, a little bit like Regulation 7.2 that simply says of the building regulations that says, well, you only can use these types of materials on external walls. That's been very game changing, but as I say, a bit of a blunt instrument, and that's not really feasible in every situation. So the alternative is changing the culture, is applying principles, which is essentially what the regulations from the Building Safety Act is doing. But the difficulty with that is that you're also putting in certain aspects, if you'll excuse the wordplay there, but it's also complex and demanding and very, very procedure heavy, as the Barry's previous talk indicated, just for one slither of this whole exercise. So it remains an extremely challenging task to coordinate the complex layers of regulations and to try and avoid, incorporate, and then communicate the lessons from errors. But ultimately, mistakes will happen, and it's just what we do with those. Thank you. And I'll hand back to Teresa.
Thank you very much to everyone. Fantastic presentations. So now we'll go to some questions. And if I may, I'll jump to you, Simon. Do you see the same sort of problems as you did 5 or 10 years ago, or have they evolved over time?
That's an interesting question. There are quite a lot of recurrent problems. For example, things like cavity barriers. I mean, there is a sort of time, I think it's a wave of issues that happens, that you see eventually dying out, and different ones come. But there are definitely there's a change, but there are recurrent problems. And as I say, it's partly because the lessons are not learned, and it really is a challenge to the industry to not make the same mistakes again. We will always be making new mistakes, but it's trying not to make those same ones.
And sorry, just to follow up on that point, why do you think we're not learning lessons?
I think in part because the errors that are made are not communicated. There's not an incentive to pool that information of a lessons learned type. People will tend towards following the rules when it's codified, when it's put down as thou shalt do this, this, and this. That you stand a fighting chance. But if it's a nuance, the construction industry doesn't. And I think human nature doesn't tend to pick up on nuance in a very reliable way. You can have a British standard that's telling you something very clearly, but it doesn't flow through from top to bottom of the industry how that should be applied. Thank
you, Simon. Alex, could I go to you next? We've got actually a question for you in the question and answer section. Maybe we should break this down. This is from Neil Munro. So should we start off with the first part, which is, on what basis can implemented compensation events be revisited?
Yeah. So it's a slightly uncertain question under NEC, and the reason I say that is because the three dispute the primary two Construction Act compliant dispute resolution clause W1 and W2 that allow adjudication give an adjudicator a wide jurisdiction to review and revise an action or inaction of the project manager. But how that can actually be used where you have an implemented compensation event can be quite confusing to the parties and also sometimes pretty uncertain when you are trying to use it before an adjudicator. The general principle is that once a C has been implemented, it can only be revised in accordance with the provisions of the contract. So you need to find a hook within the contract to allow you to revise the implemented CE. Now, sorry, I'm reading ahead in the question, but one of the examples that has been given by Neil is where the contractor's quotations were accepted by the project manager. The problem there, and you would think that you would be able to reopen and revise that in an adjudication, but we've actually had an adjudication in the last 6 months where the adjudicator decided that because the quotation was put forward by the contractor and then accepted by the project manager, that's effectively an agreement between the parties as to the valuation of that CE. And so the adjudicator wasn't able to reopen and revise that CE quotation once it had been implemented. Where that's contrasted is with a situation where the employer or the client wants to reopen and reassess an implemented CE. There is some case law that says because it's the project manager and the contractor that has agreed effectively the value and therefore the implemented CE, there is scope for the employer to challenge it. There's also almost certainly, we would say, the right to challenge an assessment by the project manager, because that is something that the contractor has put in their quotation, the PM has rejected it, and then has assessed it him or herself. So in that case, as long as you dispute that assessment as soon as possible, you should then be able to escalate it as a dispute to be revised by the adjudicator. But in short, there are very, very limited ways to revise an implemented CE, and that's why it's absolutely crucially important that your CE quotations that you're putting in as a contractor are accurate, correct, and get you everything you could possibly want at that stage. Because if the PM accepts them, then you may really have quite limited avenues to try and revise it. And there certainly isn't, arguably under any CE, like you would expect in a JCT contract, the ability or right to go back and revise everything retrospectively at the end of the project.
Thank you, Alex. That's a really good answer. Barry, can I come to you next? So how is the new registration process going for improved inspectors?
Great question. I don't have any inside information, but we've all seen those questions that have been raised in the construction press, suggesting that we could be looking at an imminent meltdown in building control. And I can't quite work out whether approved inspectors aren't applying to be registered, or whether it's a case that registrations aren't being approved. If there's a lack of applications, then we really do have a problem, because we have this 6th of April deadline. Building control needs to move to the new regime if they're to continue to exercise the function. So if there's a lack of awareness, then we have a huge problem. It may be for policy reasons that the regulator doesn't want to approve too many building control approvers under the old regime, because they want to transition to the new regime for purposes of regularity and oversight, etc. I think we need to keep watching this space, see what happens in the next couple of weeks, and that will give us more oversight as to how this is really going.
Thank you, Barry. Now to you, Ryland, last but not least. So I'm quite interested in the A to Z case you mentioned earlier. And, you know, it seems to me it's very unfair. So if you've got evidence of a party offering you money and basically admitting that they owe you a large proportion of your application, why can't you put that in front of the adjudicator? Seems a bit unfair, isn't it?
Yeah, I think it's a good point, Teresa, and obviously it's a common issue. I think the question will be, was the offer without prejudice and subject to privilege? And that will depend upon the context of the offer, the nature of the offer, you know, what it's actually saying. I mean, if a party is offering to pay part of an application, that's not different to two parties negotiating the value of the works. So unless it's clearly stated it's without prejudice, there may be an argument that what's being said is open. But I think the other point here is that if two parties agree a value, even as part of a without prejudice discussion, once there's an agreement, the shroud of privilege falls away, and you're then entitled to rely upon that agreement. And you can use what's been said, even if it was originally without prejudice, you can use that as evidence of the agreement itself. So I think it's a case of looking at what's actually been said, what's been offered, and whether it's truly without prejudice. And if it's not, you can always run it and see what the adjudicator says. But it could be a slightly high risk strategy if, of course, the adjudicator relies on it, and it subsequently turns out that they shouldn't have. and obviously then you may have a problem on enforcement.
Yeah, so I suppose with AZ and BY, the challenge there, if you're in a similar situation, is, I guess what you're saying is really be sure whether these offers are being made without prejudice or whether they're open offers.
Exactly.
Because we've had experiences of where there are sometimes open offers made, and whether or not you should really put that then in front of the adjudicator.
Yeah, precisely. Yeah, because you often have negotiations running in tandem, don't you? Some WP and some not, and sometimes there is a blurred line. So it's about clarity in those offers, I think.
Yeah, that's great. Well, thank you very much. And I think that's all we have time for today. So thank you very much for joining us, and we hope to see you next time.